5 seconds to go. Start. They do not only champion the group interest of a certain class of citizens, but instead advocate for a larger vision of a justice oriented society, a society where discrimination and exclusion are addressed and eliminated will create a just and equitable system for all persons regardless of their identities. To be intersectional is to see the common goals across vectors of identities by eliminating systems of discrimination. It is a call to eschew from simplistic identity reductionism and to imagine meaningful remedies for marginalized groups and persons. It calls for a world with equity and justice where our uniqueness forms part of benign differences among people and lends vibrance to our diversity. The Constitution enables this project of fraternity by guaranteeing rights to life, dignity, freedom, equality, and non discrimination inter alia under Articles 21, 19, 14, and 15. When reasonable accommodation is denied to a person with disability, it amounts to discrimination and violates the fundamental rights of the aggrieved person and the preambular virtue of fraternity, along with justice, liberty, and equality. Persons with disability are not objects of pity or charity, but an integral part of our society and nation. The advancement of rights for persons with disabilities is a national project along with eradication of all forms of discrimination. A component of this project is the inclusion of persons with disabilities in all pursuits of life. In Vikas Kumar Supra, this court opined that the most significant loser of a rigid, inaccessible system is the system itself. The court resonated the idea of a generation of persons with disabilities who take it as their birthright to access the full panoply of entitlements. This court has held as follows. When competent persons with disabilities are unable to realize their full potential due to the barriers posed in their path, our society suffers as much, if not more, as do the disabled people involved. In their blooming and blossoming, we all bloom and blossom. The most significant loser as a consequence of UPSC's rigid approach in this case of refusing to provide scribes to those not having benchmark disabilities is UPSC itself. For it is denying to the nation the opportunity to be served by highly competent people who claim nothing but access to equal opportunity and a barrier free environment. Cases such as the present offer us an opportunity to make a meaningful contribution in the project of creating the RPWD generation in India, a generation of disabled people in India which regards as its birthright access to the full panoply of constitutional entitlements, robust statutory rights geared to meet their unique needs, and conducive societal conditions needed for them to flourish and to truly become co equal participants in all facets of life. When we create avenues for inclusion, we work towards improving systems and institutions. In the context of healthcare, the inclusion of persons with disabilities is a vital component of quality healthcare. The guidelines and recommendations which express concern about lowering the standard of medical practice on account of persons with disabilities miss the fact that these standards may not be adequate to begin with. The quality of a system is informed by its ability to empathize with and relate to the recipients. A system without adequate number of practitioners who have lived experiences will not be able to fully imagine the obstacles and grievances faced by a diverse population. Diversity of workforce is crucial for a diverse society so that everyone may have a stake in the system and the system can effectively discharge its duties towards everyone. Section 25 of the RPWD Act outlines the positive obligation of government and local authorities to provide health care to persons with disabilities. An affirmative obligation is placed to ensure that persons with disabilities receive a barrier free access to all public and private healthcare institutions. Removal of barriers can only be achieved if persons with disabilities feel comfortable while accessing healthcare. The barriers faced by a person may be physical, psychological, and attitudinal. The inclusion of persons with disabilities within medical practice is vital to ensure that the approach of the medical community and of hospitals and other healthcare institutes is humane, sensitive, and informed by lived experiences. It strengthens our fraternity. Therefore, the process through which medical aspirants with disability enter the profession must be compatible with constitutional and statutory entitlements and guarantees. The United Nations Committee on the Rights of Persons with Disabilities, in its concluding observations on the initial report of India, has inter alia identified the medical model of disability as a prominent concern. It has stated as follows: the prevalence of the medical model of disability in legislation, public policies, and attitudes concerning persons with disabilities, particularly in the multiple assessments and certification of disability, and the requirement for different assessments to access services in the community, and in the misunderstanding of disability, including leprosy, as solely a biological condition requiring prevention and rehabilitation. The committee has recommended that the concern be remedied with inter alia reforming guidelines assessing persons with disabilities by adopting a human rights model. The recommendation has also opined against the multiplicity of assessments which we have echoed above. The recommendation states as follows: reform the guidelines for assessing and certifying disability to bring them into line with the human rights model of disability, ensuring that organizations of persons with disabilities are involved in the reform, that multiple assessments do not create an undue burden for applicants, and that policies and programs shift from care, treatment, and protection towards the removal of environmental and attitudinal barriers which prevent equality and inclusion. We have noted above that disability assessment boards must comply with rule of law principles by injecting transparency, fairness, and consistency in their approach. The boards must further elaborate on the reasons for the outcome of their assessment, in particular when they opine that the candidate is ineligible. The disability assessment boards must focus on the functional competence of persons with disabilities and not merely quantify the disability. The quantification of disability is a task in need of a purpose within the human rights based model of disability. The functional competency approach to assessment for a medical course is globally recognized. To enable members of the assessment boards in effectively applying the functional competency test, they must be adequately trained by professionals and persons with disabilities or persons who have worked on disability justice. These trainings must be with a view to enhance the understanding of the board members in assessing persons with disabilities and must not pathologize or problematize them. The disability of a person is quantified at a time of availing a unique disability ID card. The quantification of disability is moot at the point of admission to educational courses, since the eligibility for a person to benefit from reservation may be evaluated using the quantification in the UDID card. If a person with disability wants to have themselves reassessed so as to verify whether their disability falls within the prescribed parameters for reservation, they may choose to do so by updating their UDID cards. The role of the disability assessment boards must be tailored with a functional competency approach only for the course which the candidate seeks to pursue. Stop.